Judge H.F. Inderlied, Jr. I am a retired judge from Geauga County. I have been assigned to this case by the Chief Justice of the Ohio Supreme Court. That is the standard procedure for visiting judges to be assigned to hear cases in particular counties where the sitting judges are not hearing the case. The reason for not hearing the case is that it involves a variety of other public officials in the same county, and this is a common procedure. At this time, the remaining items for consideration, or the current items for consideration, are the motion for relief from judgment or order by the plaintiffs in this case relative to the order that this court made, this court being myself, appointing counsel at public expense for Mr. Ziegler. In the first instance, the court did in fact grant that appointment and make that order. The court is at liberty to revisit that issue pursuant to the motion for relief from judgment and request for reconsideration upon a grant of such motion, and I will do that. I will do that on the basis of briefs submitted on both sides of the issue, and I will do that shortly. Shortly doesn't mean today, but it does mean within the next 3 or 4 or 5 days, once I've had an opportunity to review the legal positions of the party. The parties have agreed through counsel that no evidence is required on that issue. In addition, there is pending before the court a motion for preliminary injunction on behalf of the defendant, Gary Ziegler. This court previously granted a temporary restraining order, good through today, for the purpose of maintaining the status quo until such time as the court is in a position to make certain decisions based either upon evidence presented or upon legal arguments or issues that are briefed and submitted to the court for its consideration. At this point in time, there is not all of the material necessary for the court to make such decisions. The parties agree that those decisions can be made on the basis of legal arguments and written briefs, but that there is a dispute with regard to whether all of those issues are properly before the court at the present time. The court agrees that those issues are at least technically not all before the court. In order to get them all before the court and place me in a position of resolving the specific dispute regarding the preliminary injunction and regarding the constitutionality of Revised Code Section 321.38, which by its terms permits the county commissioners, the Board of County Commissioners, to remove a treasurer from office. I need specific status changes in this case. In order to accomplish those status changes, the defendant, Gary Ziegler, through his counsel, will file on Tuesday, or before if they wish, a writ of prohibition and declaratory judgment action to challenge the constitutionality of that statute, a challenge which has already been made but in a different form, and which technically at least, may not be in the right form. It is the court's intention to get it in the right form so that I make a decision that's not challenged on some technicality instead of on the merits of the decision, regardless what that decision might be. It is the court's order that the temporary restraining order in effect till today be continued in effect until August 23rd of 2010. It is the court's understanding that the commissioners will not, in light of my extension of that temporary restraining order, hold a hearing or attempt to remove Mr. Ziegler from office prior to that time, although it is my understanding that they will and they are at liberty to provide Mr. Ziegler with a notice of hearing at that time and the contents of any required information that would constitute due process of law for purposes of holding that hearing, there being a 1922 Ohio Supreme Court decision that appears to require due process to be followed. It's the position of the commissioners that if due process is followed, 321.38 of the revised code is constitutional. It's the position of Mr. Ziegler that that statute is unconstitutional and that the only way that statute can be made constitutional is if the legislature includes in the statute specific language providing for due process to Mr. Ziegler or to any treasurer, county treasurer in the state of Ohio. So the within complaint regarding recovery of losses to the county may continue, in fact will continue, and discovery may be ongoing between the parties with regard to the merits of those claims. It is, at this point in time, subject to any further temporary restraining order, the position of the court to decide the issues presented as expeditiously as possible. That means, for those of you who don't understand that reference, I will decide this case as soon as I am provided the proper set of circumstances and the legal explanations from each side that enable me to do so. If that's 10 days from now, it'll get decided 10 days from now. If it's 30 days from now, then it'll be 30 days from now, but I will do it as quickly as I can once I have that information. Now, with that understanding, Council, is there anything for the record that you would want the court to cover prior to adjourning pending further filings and determinations? On behalf of the defense, Mr. Yes, sir, Mr. Nacon.
I believe you covered it all in your order.
On behalf of the plaintiffs, Mr. Rose.
Assistant Prosecutor. No, Your Honor, nothing further.
So that those not familiar with the process understand when that additional action or actions are filed on Tuesday or sooner, it will be the procedure that the court administrator will contact the Ohio Supreme Court and request the appointment of a visiting judge and suggest in the process that it be assigned to me so that the the 2 cases or 3 cases, as the case might be, are all under one umbrella, so that I can make the determination without having to deal with another assigned judge and the consolidation of more than one case into one to get them all in front of one assigned judge. We've just gone through that with regard to this case once, and the intent would be to avoid that process a second time. That's the plaintiff's understanding as well, Mr. Rhodes?
Yes, Your Honor.
All right, Mr. Nacon, the defense?
Yes, Your Honor.
All right. With that understanding, this hearing is adjourned pending further action.